Uh, Good, thanks. Hey, folks, thanks for being here. Thanks, Cassie, for setting this up. Folks, my name is Alex Gertzberg. I am one half of Gertzberg Licata, but Lou and I are 2/35ths of it. We've got about 35 team members here. We're a business law firm doing everything that a business generally needs, from litigation to transactions, employment law, probate and estate planning. We do a lot here. So I don't know how many of you have followed the story that Lou and I have been making. Lou has been practicing for 39 years. I've been practicing for 22 years. And 2 years ago, we merged our firms. We had two smaller business law firms. Lou started his in 1990. I started mine 10 years ago, and we merged them. And in that time, we have really grown our firms into a lot of other things besides just a law firm. We have Gertzberg Licata Acquisitions, which helps companies buy and sell other companies. We have Gertzberg Licata Talent here, which helps companies do executive recruiting. And then we spun off a company called Cover My Six, which is a tool and a process that companies use to uncover their legal minefields and then plug them up. And a lot of what Lou's going to talk about fits into one of those six components. So the premise of Cover My Six is that there are six plaintiffs who can sue a business: customers, vendors, employees, shareholders, the government, and competitors. And what we do at Gertzberg Licata and at Cover My Six is a little unique in the sense that we help companies avoid the lawsuits and avoid the government investigations. Helping clients deal with the disasters and the catastrophes of running a business from a legal standpoint, we think is kind of the easy part, and it's what most other law firms do. The harder part, and the thing that I think is more unique about us, is that we help companies avoid those lawsuits and government investigations to begin with. Once you're in it, it's just not fun. And so what Lou is going to be talking about is 1/6 of that six-sided fort that we help clients build around their companies. The core purpose of Gertzberg Licata is to create freedom and growth for entrepreneurs in their ventures. And this is one way that we do it, right? We help them avoid those lawsuits through this Cover My Six model. So I'm going to turn it over to Lou. A couple more data points about him. There are 38,189 licensed attorneys in Ohio. Of those 38, that's as of the end of 2021. So
that's very frightening. I had no idea.
I know, it's terrifying, actually. Of those 38,000 lawyers, only 763 as of today are certified in a particular specialization, and only those 763 can call themselves certified experts or specialists in their area. Of those 763 board certified attorneys, only 110 are board certified in labor and employment law. So if you do the math, Lou is part of this elite group of board certified labor and employment specialists that's 0.2% of all Ohio attorneys. And so this is a really special treat. This is Lou's happy place, helping companies avoid litigation and government investigations in the area of labor and employment. This is what he's great at, and so we're all getting the benefit of it today. Thank you all for being here. Thank you, Lou, for delivering this message, and I'll turn it over to you.
Thanks, Alex. That's a great introduction. I appreciate it. So take a look here. This is the six categories that Alex just talked about, and one of six is the employees. I'll also point out, though, that in the area of employment law, the government can also sue you, and quite often does, for overtime violations, not to mention other areas of employment liability, which could include OSHA, and some others. But overtime's a big one because, and we'll talk about this a little bit later in my presentation. The government's very aggressive about going after employees or to protect employees, going after employers who don't pay overtime, who misclassify employees. And this is an area that we'll try to give you some insight so that you don't get caught. And it's always the smaller companies get whacked by the Department of Labor. And it's a big number. I'll give you an example of a restaurant that recently got audited by the Department of Labor, was given a $275,000 fine for misclassifying its restaurant employees. We were able to successfully bring that down to $75,000 payment. But it almost put them out of business because they just weren't doing the right things. And some of it was just pure record keeping. So aside from the fact that the government can sue you in some of these employment areas, the employees can also, it's a very, very high level of, it's an area where there's a lot of litigation. And let's go to the next slide. I think Cassie's, there we go. And Cassie found this wonderful picture of a skunk. So this is what we want to avoid. We want to avoid being in any kind of lawsuit or adversary proceeding. And what we'll cover today really is only a microcosm, a small piece of the employment area. They're literally, we could do an all-day seminar. In fact, I've done all-day seminars on each of these topics. So in order to give you enough to help you within an hour, we're going to really accelerate and move very quickly. And I'm going to throw a lot of information at you. And what that means is, if you have questions about it, feel free to ask. If you want to follow up with me afterwards, that's fine. If you heard something that you say, wait a minute, that can't be true, sure, follow up with me. But I've picked basically what I consider to be the 3 or 4 steps that you can take very simply that will eliminate probably 80 to 90% of the chance of you getting in trouble. We'll go through policies and procedures. We'll go through culture and the byproduct of not having good culture. We'll go through leave of absence and just a general understanding of some state and federal laws with some other areas that you can protect yourself, insurance, alternative dispute resolutions, and maybe some other areas where you have blind spots. So let's move to the first one. I see probably the biggest preventative measure that anyone can implement is to have a policy and procedure manual, an employment manual, as we call it. This would be a manual that you would prepare with a lawyer who knows what they're doing. You would publish it, you would communicate it, and you would enforce it. These are the 4 key steps. Now, I know it sounds self-serving to say that it should be drafted by a lawyer, but I'll tell you, I've had 2 situations where employers took a manual template from a payroll company, or they went online and cut and paste employment manuals, or third, they asked other friends and business owners to give them samples and they cut and paste. In each one of those situations, we have had employees sue and the manual had a hole or a problem that could have been avoided if it was just even reviewed by a lawyer. So it's not like you have to hire a lawyer just to from front to back create these. A lot of entrepreneurs can put together a pretty good draft that a lawyer can review, tweak, and make sure there's no gaps. But then you have to literally put it out there, communicate it, enforce it. In fact, we recommend that you do so on a yearly basis, that you at least once a year kind of go through with some reminders and discussions. These are the checklist of what your basically items should be in your handbook. The disclaimer is the disclaimer that basically says this is not a contract. This is merely guidelines by which you need to operate within the workplace. This eliminates any argument that you're preparing a contract that gives an employee the right to stay with you for any length of time. We've seen lots of lawsuits where employers fire poor performers, poor employees, and then get sued because the handbook created a contract with an expectation of employment. The disclaimer is important for that. comforting information. That actually goes to maybe accelerate or advance your culture, which I'll talk about in a minute. And then you get into the legal compliance, non-disclosure agreements and conflict of interest statements can be in here. Let me put a little asterisk there. A lot of people talk about doing non-competes or non-disclosure agreements in the non-solicitation or in the area of protecting customers or protecting technology. You need separate agreements for those. You cannot rely on your handbook to enforce anything about competition or non-disclosure or proprietary rights. But in the handbook, you could talk about things that shouldn't be disclosed, privacy, conflict of interest that might arise. Then there's general employment information, safety and security, workers' comp, which is just basically what you do with workplace injuries, the typical behavior and conduct, and things that we're seeing about use of computers and social media, data security. And then the employee should have a signature page that they sign off. These are really sort of the framework, the bare bones of what every employment manual should have. And we'll get into some of the key areas that are helpful with respect to these as we move through the different topics. Let's go to I think the next slide. Yes. So job descriptions is also a really important component of your preventative workplace activity, but it's also good for operations. For those of you who are on the EOS system, you know about the accountability chart. The accountability chart has specific seats for key roles in your business. Those specific seats have job responsibilities. That's just good business practice. But in the employment area, it helps too, because there should be alignment between what the person is hired to do, their performance for that position, their compensation for that position, and the rules and requirements that have been outlined in the handbook. They kind of all fit together. So the job description talks all about these things. What's the scope of their work and their compensation, and is there a term? Is this at will? Is there a probationary period? These are all part of job descriptions. What we've seen is the job descriptions also are helpful later on when there are issues about disability compliance, or people, get terminated for performance, and they say, well, that was never in my job description. That was never anything. So this is just another preventative measure that's not only a good business practice, but typically when you have a handbook and good job descriptions, there's an alignment and there's communication that prevents misunderstandings. And most lawsuits come from these misunderstandings, these gaps, these lack of communication situations, and you want to avoid those. And that's what these manuals do. When there's a question, there's a policy in place, we follow the policy, we enforce the policy. If the policy is not working, we fix the policy. And that's what job descriptions help do. It helps sort of establish the standard, the expectation, the metric for the person as they're performing. And then later on, if issues arise, there should be some clarity with respect to that. This brings me to a part of the talk that is a little bit business oriented and less of legal, and that is the culture. So we're going to talk about poor culture that fosters discrimination. But in order to talk about that, I think we have to first talk about what is good culture. And this is, you've all been to probably some seminar that talks about, you have to have a good, strong culture. And so I will share, we believe we have a really, really strong culture. And we believe our culture mirrors in structure those other organizations that have a strong culture. So I'm going to give you sort of the key points of our culture and the culture that we've seen in other successful organizations that if you can replicate, will help you eliminate a lot of the things that give rise to discrimination suits. So first is your purpose. Why do you exist? You heard Alex tell you why we exist. We exist to provide freedom and growth to entrepreneurs. That's very important. We want people, when we hire them, to understand that we represent entrepreneurs. We represent growing entrepreneurs. We represent entrepreneurs who don't want to work for the man, so they've gone and worked for themselves, and then they can call themselves the man. But the bottom line is that they have a purpose, and people can relate to it. People can understand why the organization exists, and that dovetails into the core values. And if you have core values that people follow and adhere to and emulate, are rewarded for, that will bring people together in a community within the workplace that is sustainable. And we believe that you have to hire for those core values and for that purpose. In fact, I have a very simple filter for hiring. I believe that the world can be broken down into positive people and negative people. I also believe they can be broken down into givers and takers. And I want my quadrant to be full of positive givers, with those two criteria or traits, is I guess the better word. I know that they're going to be, assuming they have the right skill set, good employees. But that's not the end of it. The next step is to make sure that we're utilizing these people, these employees, with their unique abilities. And so we hire using a culture index. You can use DISC, you can use predictive index, you can use anything you want. But I think you need to try to use a tool that will help facilitate where the employee can best perform. Where can they be excellent, where they love what they're doing, and they make money. If you draw a quadrant square with 4 quadrants, the upper left quadrant should be, what is it the employee does that they love doing, they're excellent at it, and they make money? Every one of our employees should be put in that box. The lower right quadrant is, they hate it, they're no good at it, and they don't make money. And you'd be surprised when you put together that matrix and you start to identify for each employee what they love to do, what they're great at, what they can make money versus what they hate to do, they're not great at. You will find that a lot of organizations have people way down in that right lower box, and they don't understand why their employees are miserable and aren't doing a good job. And this creates the kind of culture that lends itself to discontent, usually departure. Because if you have positive people who are giving and they're in the wrong box and they're not doing what they love to do, they're going to find someplace else to go. And then the next step to making sure that your culture continues, you can't just, okay, so now you have a purpose and you have your core values and you start to hire for that and you look for behavior traits, you try to put them in the right position, but you have to take it a step further. We have all hands meetings where we meet regularly. Some people do huddles, whatever you want to call it, but it's an opportunity for people to communicate with each other so that they can continue to help each other stay in that quadrant that gives them the greatest joy. And we give them surveys to tell us on a regular basis if they love what they're doing, if there's things they're doing they don't want to do. And there's some other things as well. That is the kind of culture that typically survives almost all workplace incidents or problems. It is a format within which you can operate to solve problems. And when you use the legal backdrop of the employment manual and the job descriptions, it gives you pretty much all the tools you'll need to ensure that you stay out of legal trouble. You may have workplace issues, but it'll never blow up into a lawsuit or a claim or a problem. When it does, it tends to show itself in the form of some kind of alleged discriminatory behavior. So, the term discriminatory, making or showing an unjust or prejudicial distinction between different categories of people. For legal purposes, it's on the grounds of ethnicity, sex, age, or disability, just to name a few. When you develop the culture that we talked about, you typically have developed respect and consideration in the community of employees between and among each other. And when you have that, you tend to have consideration for other people's ages, their ethnic backgrounds, their culture, their sexual preference, whatever it is. And when you don't, you end up with problems. And part of the employment manual we talked about will include a anti-harassment policy. And discrimination occurs, and this is really important to understand because everybody kind of assumes that discrimination is I fire you because, or I don't hire you because, or you don't get the raise because of a certain profiling or racial characteristic or gender, right? And that is one category of discrimination, but the more important category is what we call the hostile environment. It's an environment where activity is allowed to exist, which makes the workplace uncomfortable for people who have these various characteristic traits or backgrounds. And this is where, I mean, I've got a case right now that I'm handling where somebody made a really ridiculous comment they shouldn't have made. And they said, well, I didn't make it to that person who's complaining. I just made it to the guy that I talk to all the time. And I said, well, that might be true, but that's kind of like putting a pinup of a model on the wall. I mean, that might be for you and your friend, but the rest of the workplace might not appreciate it. And so the policy that you have to have in place, which just helps guide people because they really, I mean, another case, a young woman said, what, do they only hire old white guys here? I mean, that might be true, but it starts to reveal some of the issues that give rise to harassment and hostile environments. So the policy that would be in place would have clear and unambiguous language. It's in writing, just like every policy. You get training for it. It has clear roles and responsibilities for when instances are reported. And I think this is the other part where employees really can give employers total headaches. Once the incident is reported, sometimes the employer gets more in trouble about how they handle it than what was actually going on. The situation that I described for you about the inappropriate comment that was made, it wasn't that the inappropriate comment was so bad. It's that the way the employer handled it was very dismissive. And there has to be a process in place that takes these complaints very seriously. There's an investigation, there's respect for privacy, there's a remedy put in place if there's a problem. Ohio law and most other states require a prompt remedial action, meaning it's got to be timely and it's got to be remedial. Remedial means it has to stop the conduct. It can't just be, hey, don't do that anymore. It really has to be taken seriously. And corrective action that isn't taken tends to end up becoming more of a problem. Now, again, if you have the kind of culture I just described before, where you have respect and communication and interaction, and somebody has a problem, you'd be surprised. In a culture that I described, a lot of times those issues are resolved by the staff themselves. A person may say something, a staff member say, hey, we don't talk like that here, we don't do that here. Oh, sorry, I didn't mean to offend. It's over. But even if it gets to an escalated level where it's reported, then the investigation, everybody respects it, is open, honest, and looks towards a solution. And I think that's what has to be the mindset. And the policy really is just the platform that enables that to happen. So let's move to the next area of trouble. We talked about policies and procedures, culture. Now let's talk about leaves of absences. This is an area where people get in trouble because employers get in trouble because they're not quite sure what to do in these crazy situations where their best employee is sick, they go off on a leave, they need surgery, they utilize their paid leave. The company doesn't really have any basis for unpaid leave. They keep them employed on the roster, but they're not at work. And then maybe 3 months later, they come back and they're happy to have them back because they're a great employee. Then the next month, an employee who's not so great has the same scenario. They use their 2 weeks leave. Maybe another 2 weeks goes by and the employer decides to terminate the relationship because they really don't want them back. Well, I've just described for you two situations that were treated differently. So as soon as you start treating people differently, you end up with a problem. So let's talk about the different kinds of leave and maybe how to deal with these. Again, these should all be spelled out in your employment manual, but let's go back. Yep, thank you. First of all, the first question we have to ask, and most of you on this call are at 50 employees or less, so you don't have FMLA, which is a federal leave statute. You don't have to worry about that. Once you have FMLA, everything gets more complicated. It gets more complicated because FMLA and the company's disability leave and the workers' compensation laws, they all kind of interplay and create areas of confusion. And that's why companies that are 50 employees or more have really strong HR people or really strong legal support in this area. So we're going to talk first about everybody who's under that 50. So it's everybody who's got, 4 or 5 employees up to 15, 20 employees. The first thing to understand is there's a difference between short-term and long-term. Short-term leave is usually considered to be, generally speaking, 12 weeks. And long-term leave is really anything more than that. And then the other distinction to understand is the difference between paid time off and other designated leave categories. Now, what do I mean by that? Well, I've seen policies that have vacation leave, sick leave, family leave for birth of a child, jury duty leave, bereavement leave for the death of a relative. Start picking your category, but there's all these categories of leaves, and it's 10 days for vacation, and it's 5 days for sick, and it's 2 days. And what you're doing when you create those different categories is you're creating some confusion that's unnecessary in terms of understanding. I decide, I'm going to take my sick leave because I don't want to burn my vacation leave, or I don't have any sick leave left, so I'm going to ask for vacation, or whatever it is. The bottom line is each employer should figure out, number one, on short-term leave, how many days are you willing to pay for an employee who takes off from work? Whether the taking off is because they're sick, they want vacation, they want to go to a funeral, they have jury duty or whatever. That would be paid leave. It would be considered paid time off. Versus then other areas where you could still provide the time off, but it would be unpaid time off. So for example, jury duty, we encourage, there's an obligation to allow employees to go to jury duty, and we want to encourage that, but it doesn't mean we have to pay an employee 3 months when they sit on a criminal trial that is extended. So the way to really think about this is, what is the short-term leave that I'm willing to give my employees? What is the amount of paid time off that I'm willing to give them? What are some areas where I might give them some unpaid time off? And then a catch-all category at the end that we call personal leave of absence. And the way this reads in the employment manuals is that the employee with the request of management is entitled to receive, some of it is up to 30 days of personal leave for extenuating circumstances. And this is the category that helps you with that employee who's out for a medical reason that can't come back after, 2, 3, 4 weeks, or has the surgery, needs an extra month off. And they say, look, I really could use, like the doctor says, they're going to be able to come back in a couple more. You say, okay, you know what? We'll give you personal time leave of absence unpaid. It's unpaid, but it is at least what we call a gap or catch-all that enables you to keep an employee longer than otherwise, because when they exhaust their leave, you really have no other obligation. You really have no other choice but to terminate the employment. Otherwise, they could be accruing vacation just by the fact that they're still on your roster. They may have health insurance obligations that you have to pay for, that they have to pay for. They wouldn't be entitled to COBRA until they're actually terminated under those circumstances. So this is kind of the area that has to be simplified in your employment manual. And it's usually the area of complexity. So what we do is we work very hard to simplify this. Let's go then to FMLA. FMLA, let's just knock this out. If you remember during the COVID period and the leave, there were all these emergency leave acts, and a lot of states have started to pass leave acts, and it's always this 12 weeks seems to be the magic number. 12 weeks of unpaid leave is required when employees need time off for medical reasons or family reasons or a variety of other reasons, depending on which state you're in. And so what I've seen is a lot of policy and procedure manuals try to simplify their leave by just mirroring the FMLA. They'll just mirror it. They'll say, you know what, we're going to be just like the FMLA. We're going to provide 12 weeks of unpaid leave per year. And, you know, but you can also have 2 weeks of paid. So they might say 12 weeks total, 2 weeks paid, and that covers everything. That covers the personal leave that we talked about. So this FMLA applies to 50 or more employees, but I see a lot of smaller companies sort of using the framework of FMLA to just have a leave policy that's similar. The caution I provide is to make sure that you're not just borrowing the FMLA framework, because that then imposes more obligations on you than necessary. So if you're 50 and over, you've got a lot of compliance here. If you're not 50 and over and you want to have something that looks similar to this, it's easy to do, but you should do it within the framework that I gave you for the short-term leave. Let's go now to state and federal employment laws, which is reason number 4, a lack of understanding. I'm going to pick like 2 areas or maybe 3 where you will see lots of small companies get in trouble just because they don't know what to do. Let's go to the first one, which is Americans with Disabilities Act. Now, the Americans with Disabilities Act is a federal law, but virtually every state has a comparable state law. Yeah, you need to go back 1 slide, please. Okay, now, so when we talk about Americans with disabilities or any kind of disability law, it really is both federal and state. 15 employees if you're federal, but it doesn't matter because the state law pretty much is the same. And here's what the 2 things you need to know. It used to be that there was a question about whether the person had a disability, and you could argue about that. And then it used to be whether you had to provide a reasonable accommodation, and then it was, what is that reasonable accommodation? All of that has changed. There are 2 things you really need to know here. Number 1 is almost everything is considered a disability under the Americans with Disabilities Act and under the state laws that are similar. Almost everything. Sleep disorders, anxiety conditions. We're going to assume that people who are claiming that they need an accommodation, meaning they need help in some way, probably have an underlying disability. And here's the the scenario. We're not talking about people who have serious conditions that are obvious that need help, accommodations. We're talking about the ones that you don't really know about, like anxiety disorders, right? And so the employee is not performing well. And you sit down with them in a review and you say to them, you know, your performance has been really not up to par lately, and it has to improve. And can you tell us what's going on? Why is it? And they say, well, you know, I have a problem. During the meetings, I really have a lot of trouble paying attention. And the question that you are now obligated to ask, it's called the interactive process, is how can we help you? Once they tell you they have a problem, and that problem is the reason for their performance, or that problem is the reason that is interfering with their ability to be at work on time or to do what you need them to do, the employer has an affirmative obligation to engage in the interactive process, which is a simple question. How can I help you? You don't have to ask them, what is your condition? You don't have to ask them, and you shouldn't, what has the doctor said? The question is simply, how can I help you? And if they say, you know, it'd be really helpful for you to tape the meetings so I could listen to them later, or it'd be really helpful if I could have, you know, some extra time, or, I mean, there's all kinds of crazy requests that come out of that question, but it at least puts you in a position to evaluate. Is this something I can accommodate? Is this a reasonable accommodation? Is this something that we can do? If it is, then you're in a position to say, okay, you know what? We're going to do that for you. And we expect then your performance will improve, and we'll come back in 2 weeks or 30 days and take a look. The worst thing you can do is to say, the person tells you they're having a problem and that's the reason their performance. And you say, well, that's too bad. You need to like either improve your performance or you're gone. There are so many lawsuits that are coming out now because of psychological conditions, because of stress, because of a lot of these like not visible, we call them, disabilities, that the employer is just not interested in engaging in this process and trying to accommodate, that these employees get terminated and then they go get a lawyer and the lawyer files a claim or sends a letter, and it may only be a $5,000 or $10,000 claim, but it's money that ends up typically coming out of the employer's pocket. And especially even if they have insurance, which we'll talk about in a minute, it can end up being your deductible. So this is the Americans with Disability protection that you need. If it gets beyond that, I mean, if it gets to a point where a person has a real disability that needs accommodation, then you got to get your lawyers involved. And what we do is we go to the doctor. We say to the doctor, here's the job description. Remember, we talked about job descriptions early on. Here's the job description. Can this person perform this job either with or without an accommodation? And if it's with an accommodation, what is that accommodation? And then it's usually on the employer. The obligation is usually on the employer to provide that accommodation, unless that's not possible. That's the process for ADA. And again, this is a topic that we could talk about for a long time, but that should give you enough to know that you need help, either in terms of going into the interactive process or calling your lawyer to say, okay, look, I think I have a problem here. I just want to make sure I process through this the correct way. Let's go to the next. State and federal safety obligations. There's a lot more OSHA fines being doled out. There's even, I saw some requirements that OSHA accident reports get filed immediately. There's a lot going on here. The key, I would say, for both of these is, the state version of OSHA is the Industrial Commission of Ohio. They have a division of safety and hygiene. The key here is to maybe be a little proactive. The Industrial Commission of Ohio Division of Safety and Hygiene will come and do an inspection of your place for free and give you a list of items that are considered to be safety violations with no penalty and no future penalty associated with those. It's a free audit that gives you kind of a way to say, okay, we've got a clean bill of health. It's really, if you have like any kind of facility, warehouse, manufacturing facility, I know that even some high-level clerical office places have done this, because they'll come in and they'll look at ergonomic issues and they'll give you a report that basically tells you where you can improve safety and your safety obligations. OSHA is not so kind, but the state audit or investigation will help on the OSHA level too. These are just areas to be aware of. Do we have safe workplaces? Let's go to one more. Let's do overtime. Yeah, this is another one where employers get into trouble all the time. So I'm going to give you sort of the 5 areas where employers get in trouble. Number one is they classify employees as exempt when they're not exempt. They classify them as, oh, they're exempt. I don't have to pay overtime to them. And they make the mistake of thinking that just because they pay a salary, the employee is exempt. So he's my manager, I pay him a salary, he's exempt. Not true. There are specific categories for exempt employees, and there are specific criteria for those categories. In most cases, your employees are not exempt. And in most cases, no matter how you pay them, they do not get the exemption. But if you do not pay them salary and they are exempt, they will not be exempt. So let me say that again. If an employee is exempt, you have to pay them salary. You cannot pay them hourly and still have them being exempt. A 40-hour work week is how we calculate overtime in Ohio, not an 8-hour day. You can work an employee 3 12-hour days or 4 10-hour days. You don't even have to give them a break, believe it or not. I don't think that's a good business practice, but under the overtime and wage and hour laws, the question is, did they work more than 40 hours a week? If they did, you owe them overtime. And then there's no such thing as comp time. Comp time is, hey, thanks for working 50 hours this week. You've got 10 hours off whenever you want to take it. That doesn't work in Ohio. And the last is record keeping. Most employers get in trouble because they have no records of the hours that employees are working. And trust me, if you don't have records, the Department of Labor wage and hour investigators will create records for you. They will generally talk to employees who say, oh yeah, I work a lot of hours. I work 10 hours a day. They will create records that establish, as in the case I explained to you, $275,000 in back wages, overtime, and penalties. And so you really need to keep records. Let's go to a case that just came out. This is interesting because one of the exemptions for overtime is what we call highly compensated employees. And I don't remember it's somewhere around 105,000, somewhere around 100,000. If you're paying an employee a lot of money and they're considered to be highly compensated, then they can be exempt. Except, remember I told you, they lose the exemption if you don't pay them salary. In this case, the employer was paying more than $200,000 to an oil rig worker, but they were paying them based on like a per day amount. Every day you worked on the rig, you got a big check. And if you worked 10 days, you got a big check based on 10 days. If you worked 15, you got a big. So this was an employee at 200,000 that was classified by the employer as a highly compensated employee. But the Supreme Court just ruled that the fact that this employee was not paid a salary, instead was paid based on the number of days they worked, voided that exemption. So this overtime area is pretty tricky. It is the area that gets employees in a lot of trouble. And why do I raise this? Because a lot of companies say, well, look, we'll just make them independent contractors. Well, that's where the Department of Labor loves to come in and take a look and say they're not independent contractors. Now you owe them overtime, and they will tell the IRS that you've misclassified people, and the IRS may come in and audit you, and then you'll have tax issues as well. Independent contractor agreements. So in order to have an independent contractor, the person has to qualify. There's like 20 or 21 guidelines. You can find these guidelines on the IRS website. And believe it or not, the only helpful thing the IRS has done, I think, ever, is they provide a sample agreement on their website of what constitutes a good independent contractor agreement. If you do not have a written agreement for an independent contractor, you are not allowed to argue that they are independent contractors if you are audited by Department of Labor or IRS. They will be considered employees immediately because you do not have a written agreement that states otherwise. That's just the starting point. Then you got to go through the other criteria. What do we got next? Let's talk about, other than what I've just explained, what are some other strategies that you might be able to protect your business? Well, remember, we're talking about risk. So what's a good way to shift risk? Insurance. EPLI insurance is called Employment Practices Liability Insurance. Employment Practices Liability Insurance is different than your general comprehensive CGL, comprehensive general policy. It is usually a rider, but sometimes it could be a separate covered policy. It is not that expensive, and it will cover you if you get to, on a limited basis, if you get sued by an employee for a wrongful termination. You fire the employee, they come back, or the employee quits because they say, I had a hostile environment, I have to quit. So they quit. Then they sue you. The policy will provide a lawyer that will provide you with the defense. But there's a lot of exclusions in these EPLI policies that aren't covered. For example, contract damages are not covered. Punitive damages are not covered. So what you really get in the EPLI insurance is the cost of the defense, but also if there's ultimately a settlement, there's a high chance that the carrier will pay the settlement, because basically they evaluate the cost of the defense and say, well, it'll cost us, $150,000 to go to trial on this case. We could settle it for 25 or 50,000. We'll just settle it. So this is something worth looking into. If you don't have a policy, you should talk to your agent. You should ask them about this coverage. You should find out how much it costs, and you should give serious consideration to it. What else do we have? Let's see. ADR, one of my favorites. So alternative dispute resolution really consists of two key pieces. The first is mediation, which is always non-binding. It's the opportunity to bring a neutral third party in to try to negotiate or mediate an outcome that's acceptable to both sides. And the other is arbitration, which is binding. And putting an ADR provision in your employment manual will save you potentially a lot of headaches if you do have a claim, because believe it or not, a lot of these claims can be resolved through mediation, which is very inexpensive. And even if it's not, then it goes to arbitration and you're not in front of a court with a jury who tends to be very sympathetic to employees because they all work for employers and most of them hate their employers. So the opportunity here is to use ADR. I will tell you that it is required that the employee sign the ADR policy separate from the manual. So in the manual, you would have an ADR provision, but when they sign the manual, they would also sign a separate agreement that says they agree to submit themselves to ADR. So it's an ADR, alternative dispute resolution agreement, that is part of the employment policy. They sign both. And remember, I talked about like the other agreements that you might want them to sign depending on your business would be non-disclosure or non-solicitation agreements, maybe non-compete agreements, maybe proprietary rights agreements. Those all can be merged into one agreement. And I always hear this, but those aren't enforceable. Yes, they are. They just have to be drafted properly. I think the way to minimize your blind spots is taking the first step like you have today. It's looking at the things that you have in place or don't. The steps I've given you today are very simple to implement. I had a really small employer, 3 employees. They asked me for a manual. I gave them a manual. Years later, they said, I'm so glad we had that manual. We had a problem. We went right to the manual and it saved us so much headache and probably a lawsuit. It's really that simple. So I think we have a few minutes. If anybody wants to ask questions, I'm happy to answer questions. That's always a lot of fun. While you're thinking about questions to ask, we talked about CM6. If you click on this barcode, it will take you to our CM6 risk assessment. It's 15 questions. It used to be more. If some of you on here took the assessment before, it was, I think, 27 questions. We pared it down. But this will tell you if you're at risk in these 6 areas of who can sue you: your customers, your vendors, your employees, your partners, the government. So this is a really good risk assessment. It's free. We encourage you to take it. You get a little report with it. And then if you want to talk to one of us about your report, just in terms of what does it mean, that's fine. We'll do that too. But any questions? Don't be shy.
If anyone has a question, just be sure to unmute your microphone.
Yeah, unmute and say, Lou, I've got a question.
Hi, Lou. This is Cindy Baldwin from St. Gobain. How are you?
Hi, how are you?
I'm good, thanks. So we've had an increase in employee litigation and employee threats. And one of the things I'm struggling with is empowering my managers. They're so afraid of holding people accountable for performance because of claims of retaliation. So we have a problem employee who know that if they threaten, they raise a claim either for a work injury or mental distress or whatever they come up with, that the supervisors then feel handcuffed, that they can't actually hold them accountable because the people will come after them. Do you have any advice?
Well, I think the first part, so I'm gonna assume for the sake of analysis here that you you've got things in place that help with your culture, and you might be able to build on those to develop what we'll call the foundation for these problem-solving techniques later. But let's accelerate to really the problem in terms of it being on your desk. The first is to make sure the supervisors feel protected. And most companies tell supervisors that they're indemnified against any claims that's brought against them, that the company will defend them and take care of them as long as they're acting within the policy and procedures and the guidelines of the company. That's the first. And the second is, sometimes you got to draw a line in the sand. I'll give you an example. We represented a self-insured company years ago, and they kept getting these workers' comp claims, and they were ridiculously stupid claims, and they were settling them, right, for $5,000 a claim, just because it was easier to settle them. And we sat down and we talked to them, and I said, if you want these claims to stop, you've got to just say no more money. And I said, it's going to be hard to do because the first claim is probably going to be a nuisance claim, and you might be asked to pay like $2 or $3 grand, and you're going to have to say, no, we're not going to. And they agreed, and we did that. And sure enough, the first claim came in, and the lawyer, like the day before trial, said, hey, would you just pay the filing cost, $500 plus? And we were like, no, we're not paying any money. This is not a good claim, and we're not paying. And they dismissed the claim. And then all of a sudden, the word got around, and the employees quit filing these ridiculous claims. They went to having all these claims to having like no claims. And so similarly on the follow through on, I'm hurt, I need to be accommodated, or you've got to have a procedure in place that you can just follow. And sometimes you got to just say, look, this is our policy. This is how we're handling it. We're willing to accommodate you. We're willing to work with you. We'll engage in the interactive process, or we're going to do the investigation. And this is our conclusion. And you might have to stand ground one time to make it go away.
Thank you.
I don't know if that's helpful, but that's what we've learned.
Thanks.
Yep. Anyone else? Don't be shy.
All right, last call for questions.
I really appreciate all of you sitting in. I really miss the in-person seminars. First of all, I'm more of a performer than this video stuff, and I can read the room better. I can make jokes without, I'm making sure I'm not making the wrong jokes. And but to sit through a webinar, I know sometimes gets like old because there's just a lot of them going on. But I appreciate it very much. I hope we've been able to help you protect yourself. I hope we moved the needle a little bit for you. And, we are committed to providing freedom and growth. And this is part of that freedom from being sued, from having to deal with spending your money on lawsuits as opposed to building and growing your business. So if you have a question later about anything I've talked about or anything I didn't talk about, please reach out to me. I'd be more than happy to talk to you. So thank you very much.
Thank you, Lou. We'll circulate a